appreciate you coming.
Thank you, everyone, for coming out to Big Z's here. We are the Katy Lions Club, like President Carroll mentioned. We have ADA Jarrell Rogers as our guest speaker tonight. We're so grateful to have him here. He's going to talk to you a lot more about what his background is, what he's looking to do, how amazing he is, and everything that he has accomplished in his life. So I'm not going to spend a lot of time talking about him. Just suffice to say, in the Katy Lions Club, we believe in education and we believe in helping young people. And this amazing man, he does that as well. And plus, I'm just going to say it here. If y'all look at his Facebook page, it's pretty easy on the eyes too. Before I turn it over to him, I just want to say, if you look at this amazing lady, Tiffany, in coral, or the woman, Maddie, in the purple shirt behind her, those two ladies, they have the 50-50 raffle. 50-50 raffle, that helps us as an organization support the community. You know, we have the Katy ISD partnership where we do vision. You know, we actually help kids. If a young child needs glasses, we work with the parent, we work with the school, we get them those glasses. And this, you know, this 50-50 raffle helps afford that, helps cover those costs. So without further ado, ADA, Jarrell Rogers.
Good evening, everyone. Thank you so much for having me. Thank you for the kind words of welcome and introduction. So yes, my name is Jarrell Rogers. First time being able to speak with the Katy Lions Club. I'm excited about it. Hopefully not the last time. So I appreciate you all having me and I'm really thankful for this opportunity. As you mentioned, I'm an ADA and I've learned in my time being an ADA that sometimes people don't even know what that is, right? And so my whole plan for my little talk, my 10 minutes, 15 minutes, however much time I get, is just to kind of give you a background in regards to what is happening in the courthouse, ADA being Assistant District Attorney, just kind of giving you some basics about what's happening in Harris County, and then more so to give you all a chance to ask questions, right? We see a lot of things in the media, we see a lot of things in the news, papers, and there's a lot of confusion sometimes about what's happening and things of that nature. So I'm hoping that this will be more a chance so you will learn a little bit about me, but also for me to inform you just about a few things. So just briefly about me, just because I just always find it relevant to tell people who you are, like who's this guy talking to me? I'm originally from Louisiana, born and raised in Shreveport, but I've been here since 2008. I first came to Houston as a teacher. I was a teacher at Sharpstown Middle School. I taught 8th grade English, but then I decided to go to law school. I'd always wanted to go to law school, and so I left Houston. I went to Baton Rouge, where I went to LSU for law school, and then I've been back here for good since 2013. As it was mentioned, I'm an ADA being Assistant District Attorney. And so I work for the elected Harris County District Attorney. That is Kim Ogg. I am one of a couple of hundred Assistant District Attorneys. We all have that exact same title, Assistant District Attorney, Assistant District Attorney. And so currently our office, they place you in different places, right? And so you're assigned to different divisions. So the current role that I serve in as an Assistant District Attorney is as the Chief of the 180th District Court. All right, so a little background now about what that means. So when we talk about the criminal courthouse is located 1201 Franklin Street, downtown Houston, Texas. All right, so you have two kinds of courts in Harris County or the state of Texas. You have your county courts. If it's a county court, that's going to be a court with your misdemeanor cases. Misdemeanor cases include things like a DWI first, a DWI second, assault, trespass, theft, right? So your misdemeanor cases are typically what we call your low-level offenses, but they still carry very serious consequences, right? So if someone was to be found guilty of a theft and have that conviction on their record, that can affect their employment, applying for credit, housing, jobs, and things of that nature. But that's what happens in the county court level. There are 16 misdemeanor courts. They all hear the exact same cases. So whether you're in County Criminal Court 1 or County Criminal Court 16, it doesn't refer to a part of town. It's the exact same jurisdiction. All the numbers do is just distinguish one court from the next, all right? If you were to be charged with a misdemeanor offense, the max time you could face incarceration in jail would be a year. The range of punishment is 0 days up to a year if it's a Class A, 0 days up to 6 months if it's a Class B misdemeanor, okay? So that's one part of the courthouse, the first couple of levels, but then you go beyond that And you have your district courts. Your district courts, that's where they hear felonies, right? Felonies are what we typically know as the most serious cases. Felonies include things like murder, okay? Murder is a felony, in case you didn't know. Capital murder, aggravated robbery, things of that nature, okay? So the range of punishment on felonies all over the place, because you have what's called a 4th degree level felony, or what's really called a state jail felony, where the max is up to 2 years. Then you have a 3rd degree, range of punishment is 2 to 10 years, 2nd degree, 2 to 20 years, and your 1st degree, 5 to life. So those are the range of punishment on those cases. So in my particular position as the chief of the 180th District Court, what that means is that I handle the murders and the capital murders. So if someone is charged with that type of offense and it gets filed and it happens to land in my court, then that is my case. My job as the assistant district attorney is to request all the evidence. That's going to be things like offense reports, 911 calls, surveillance video, DNA testing. I'm the one that makes sure that those things are done, because as an assistant district attorney, I have a legal and ethical obligation to make sure that the other attorney, the defense attorney, has all the evidence. There's a law, it's called the Michael Morton Law, 39.14 of the Code of Criminal Procedure, and it bounds me, anything that is in the state's possession, constructive possession even. So meaning if the police have it, and I don't even have it in my file, but if HPD has it, or Webster PD, or Katy PD has it, I am deemed to know about it. And I have an obligation to make sure that the defense attorney has it. And so sometimes when you hear about these cases on the news, you hear about the backlog, sometimes that's some of what it is, because you can probably imagine getting evidence now in 2022 versus evidence that may have been 30 years ago. It's totally different, right? 30 years ago, the evidence for a case may have been a VHS tape or maybe a 911 audio recording, right? But now there is so much evidence. We talk about the data from a cell phone tower, right? That might show where a suspect was at a given time. We talk about phone records. We talk about Snapchat records. We talk about Facebook records. We talk about all these different things, right? TikTok, Kick, all these different ways that people use to communicate. Well, the issue is that is where a lot of our best evidence comes from. But the thing is, it takes time to get that evidence, right? Because just because I know that you committed a crime and there's evidence on your phone, we still have this thing called the 4th Amendment, right? The 4th Amendment still guarantees you privacy. And so in order for me, if I even want to try to get those records, right? Facebook doesn't just want to release those records all, recklessly, because then who's going to want to use Facebook if they're not having an interest in your privacy, right? Apple, if you keep up with the news, they're constantly updating the iPhone to make it impossible, to make it harder for law enforcement to get in there. And so there's this constant battle in terms of 4th Amendment protection, as well as making sure that we ensure public safety. And so what that means is that oftentimes the law enforcement, they will have to seek a search warrant to get into that, right? They will have to seek a search warrant or a court order that will allow them to get into that. And the only reason I mention all that is just to say that as a chief prosecutor, as any prosecutor, one of our biggest responsibilities is making sure that we get the evidence. So I can safely say for myself, all the coworkers that I know, we want to make sure we do that as well, because nobody wants to have someone prosecuted improperly, right? We have an interest in making sure that any conviction that might possibly be attained is a righteous and a just conviction, because it is our name, it's our license, and also it's someone's freedom that's on the line here. And so that's a little bit about what I do. We gather that evidence, we make sure the defense attorney has that evidence. If we don't reach a resolution, then we go to trial. And that's probably my favorite part of the job. I love speaking to juries. I love being in front of the juries and making a position. I love being in front of a judge and making arguments. And so that's probably the most exciting part. I was just in trial about 3 weeks ago on a aggravated sexual assault case. And it was very time consuming, it's very emotional. But again, you don't go to law school to become a prosecutor and then shy away from challenging tough cases, right? That's what you go to law school for. And so I'm happy to say that, I'm not gonna say post-pandemic, but at this point in the pandemic, jury trials are resuming. They're resuming in a safe manner. It varies from court to court in terms of how they're specifically doing it, but the courts do allow for social distancing. The courts do allow for the jurors to wear masks. And so if any of you do receive a jury summons, I would encourage you to comply with it. I would encourage you to go to the courthouse, because that's also part of the backlog. We have to have jurors in order to try the cases. Some of the reason that the backlog happened is because both sides, prosecutors, defense attorneys, defendants, everyone knew that there wasn't a jury coming, right? And so when you knew that there wasn't this someone to decide the case, then you know people are less willing to plead guilty. Prosecutors are less willing to dismiss it, because all that means is that, well, we just have to reset. We're just gonna keep the case lingering and lingering and lingering. And so jury duty is what makes cases get resolved. And so everything I've heard about the Katy Lions Club, it seems like this will be a great group of jurors. And so whether it's you, your family, your friends, no, I'm being serious, because you recognize the importance of community. From what I was hearing, everything that the club is organized or that they're responsible with, and that's what a juror should be. Someone who understands the importance of community, someone who understands the importance of civic duty, someone who understands that obligations in terms of doing their part to contribute to a larger whole. And from what I've been hearing about the Katy Lions Club, that's a big part of what this organization believes. And then the last thing I'll say, I don't know how I'm doing on time, but that's the last thing I'll say, and then we can open up the questions. I would say the elephant in the room. I'll say the lion in the room. The elephant in the room. We always hear about, as a lady, we hear about bail reform. And I just want to say this. When you talk about bail reform, you just want to make sure that what you're hearing is that you want to make sure, what that means is that that we're in the process right now trying to make sure that everyone in Harris County, if you're charged with a crime or something, that we make sure that the laws apply properly and that people are held accountable when done so. And so you hear these news stories about someone being released or something like that. And I'll simply say this, that the Constitution, for the most part, allows for people to have a bail, to have a bond set. And so whenever you read the article, just make sure that you're reading it with a fine-tooth detail. And I'm happy to talk about that more in detail if anybody wants to talk about it one-on-one. But the county, I think as a whole, I'm confident in saying, taking strides to make sure that things are being done the correct way, the just way, the appropriate way. But at the same time, you do want to make sure that you want to follow the Constitution. And I think judges want to follow the Constitution. I know the DA wants to follow the Constitution. I know the defense attorneys want to make sure that the Constitution is applied. But the thing about law is that, well, it has different interpretations, right? That is the nature of law, that you can have the same article. You can have the Fourth Amendment about search and seizure. You can have the Eighth Amendment about cruel and unusual punishment and bail. And you get three different lawyers who have three different interpretations about it, right? What the Fourth Amendment meant 20 years ago, the Supreme Court says it means differently now. And so that's a big part of what we're seeing now in terms of what does it mean, when can someone be held with or without bond. And so for anyone that's interested in that, we can talk about that afterwards, or you can also go to the source, which I always tell people, Article 1 of the Texas Constitution are 11A and 11B. So it's a good, casual reading if anyone's interested in that. If you need something at nighttime to read. But I don't know how I'm doing on time, but I'm definitely willing to open questions or keep going. Okay, all right, I'll keep going. So I'll keep going. But sticking with that though, and so I'll just go ahead and go into a little bit about that. So as I was saying, the Constitution allows in most instances, and I'm talking about the United States Constitution right now, allows in most instances for someone charged with an offense to be entitled to a bond, right? That is their constitutional right. Now, the law also does allow exceptions for that. Let's just say one example of an exception is that if someone has been to prison twice, and then they're now charged with a criminal offense that's a 3rd degree or higher, then under certain circumstances, that person could be held at no bond. Or if a person is currently on bond for an offense, and then they pick up a new offense, that could be, in the right scenario, a case where someone would be held at no bond. But what's important to remember is that it's not enough just because of the accusation. There are things that the law requires in order to be proven for that person then to be held at no bond, because regardless, you are still presumed innocent, right? The Constitution guarantees us that right. You have a Fifth Amendment right, and so people are still presumed innocent. And so the arrest doesn't automatically mean that someone's going to be held at no bond if the scenario applies. There will still be things that will need to be proven to a judge, and they'll need to be proven in the legally correct way, meaning the rules of evidence need to apply, and other different things like hearsay will not be admissible typically sometimes. And so those are some things that happen, and oftentimes there are strategic reasons why a prosecutor may decide not to ask the judge to hold someone at no bond. Again, that's something I can talk about more in detail. It's probably not that interesting to talk about up here, and it's probably get nuanced, but there are strategic reasons why a prosecutor might not ask the judge to hold someone at no bond. But at the end of the day, the prosecutor does need to ask that question. At the same time, though, if the prosecutor asks, the judge also needs to be willing to have that hearing if that is in fact the motion that is before the judge. And so people love to point fingers, and all I'm here to say is that if you want to point fingers, there's a lot of blame to go around. There's blame to go around on the prosecutor's side, there's blame to go around on the defense attorney's side, even the judge's side. And so at the end of the day, everyone needs to just do better. At the end of the day, if we're going to be honest, everyone needs to do better, and everyone needs to just do better in terms of working together and not against each other. Because when you're focused on trying to figure out, well, who's to blame, you kind of get lost in the shuffle about the big picture here. Because at the end of the day, you have community safety that's on the table, and you also have defendants' rights that are on the table, and you also have victims' rights on the table. And so that needs to be what's focused on, as opposed to who's right, who's wrong, who needs to get fired, who needs to get this and that. And so I would just encourage people to make sure that when you read these stories or anything like that, just make sure that you're reading it and that you're asking pertinent questions, and that you hold people accountable when need be. What else? Okay, we can do Q&A. Okay. So that being said, and I know I said a whole bunch of random things probably, but anything that's of interest, any questions, anything that you all have as a teacher, this is the part that I like really. I always like answering questions and such. So yeah, go ahead.
Okay, piggybacking off of you were a former teacher.
Yeah.
How has your knowledge of being a teacher impacted your role as being a judge?
Yeah. So well, as being a prosecutor. Yeah. So as you said, former teacher, I taught 8th grade. And as teaching 8th grade, teaching in the area that I taught in the Sharpstown community, I saw a lot of things, right? It didn't take long before I was exposed to the gang issues that were prevalent in Sharpstown. You had the rival gangs, you had the La Primeras and Cholos, and that's the robbery gang there. It didn't take long before I was exposed to the issue of teenage pregnancy. That was a very real issue. You're exposed to the issue of poverty, high crime area. And these are all issues that the students went to school with every day, right? They can't separate themselves just because they enter the school hall, just because they're over there at Sharpstown, Triola Lane. It's not like those issues don't exist anymore. And so having to realize that, I was able to see that, I have a lot of great kids. I have a lot of kids with potential. I have a lot of smart kids, right? But at the same time, they have very real issues. And so it's about separating the issues from the child themselves, right? And not letting those issues define the child, and making sure that the child realizes that too, right? A lot of times the child will then go into this thinking of mode like, this is all I am, this is this and that. But if they have someone that can recognize their potential, or the smallest little compliment, when they do something good one day, or they do the right thing one day, or you see progress in them, you see growth in them, for that to be acknowledged, that goes a long way in the eyes of a 12, 13, 14-year-old, right? So when you transition that now to what I'm doing as an attorney, as a prosecutor attorney, I see that same kind of thing, right? I can easily, if I so chose to, look at someone's criminal history and write them off. But I think that wouldn't be doing my job properly. The law tells me that my job is to seek justice, right? And so part of what I do is try to see, okay, well, has this person ever been on probation before? Has this person ever had a chance to prove themselves able to comply with rules and regulations? Because one of the things that probation does is that it sets guidelines for a person, right? For a person that doesn't necessarily maybe have order in their life, it gives them order to say, okay, you have to check in with this person, you have to come in and get tested, this and that. And on one hand, it can certainly sound inconvenient, But on the other hand, prison can also be inconvenient too, right? And so on one hand, it's a way to stay out of prison, and it can provide structure for someone who's never had structure. Now, of course, if you don't comply with probation, then then we have different ways to address that as appropriate. But one of the things though that I've learned from teaching is that you have to look at people as they are. No two theft cases are the same. No two aggravated assault cases are the same. No two murders are the same. You have to look at it case by case example, and you have to be willing to use all the tools that you have available in your arsenal, right? I can't look at every case and say, okay, prison, prison, prison. I can't look at every case and say probation, 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 right? I have to look at every case, and I have to be willing to listen to the arguments that are presented by the attorney. Sometimes the issue on a case is guilt or innocence. Can I prove that this person did this? Can I prove or can I not prove that they did it? Sometimes guilt innocence is not a question. Sometimes the question is, okay, but what's the appropriate resolution here, right? And so a lot of times that is what we're trying to figure out. What's the proper resolution here for the defendant, for the victim, for the community? And so I think teaching has helped me a long way in realizing that people are more than what they may just present or what their past may say about them or what their neighborhood and other circumstances predict about them. And that's a scratch or just anything else?
So we have a question from our Zoom people.
Yeah.
What programs in place to assist persons released from prison to prepare to re-enter their community?
So if you want to talk about programs for people actually released from prison, that I have less familiarity with because we, as a prosecutor, we're not involved with that particular part, that aspect of it. I can talk about different programs that people have, whether they're on probation or whether they're have a case pending. And so in Harris County itself, there are a number of different specialty courts that they have. And so again, this is not post-prison. This is usually probation. All right, so very different. And so in Harris County, you have a number of specialty courts that I think are doing awesome jobs because they target the individual, the community that needs particular help. So one example is that you have a veterans court. You have a veterans court, and what we've done in Harris County, we've recognized that veterans have different needs, maybe than sometimes from non-veterans, or that they have different issues that need to be addressed, and that they typically might excel in an environment with other veterans. And so we've taken this group, we cut them out in a subsection, and they can have their own specialty docket if they're eligible. They have certain different criteria they got to meet, and they get treatment that's tailored towards them, and there's different requirements to be involved with that. We also have what's called a sober court. So that's for DWI. So people who appear to have a substance abuse issue, right? Again, you could go to prison for DWI, and in some instances that is appropriate, right? But a lot of times people are, it is a substance abuse issue, it's a mental thing, and of course, Harris County has recognized that sometimes people need treatment, right? People need to be treatment in order to be better, in order to be productive citizen of society, in order to be productive husband or wife or brother, uncle, or things like that. And so it is an intense form of probation. And so they have to be willing themselves to seek the help, right? They have to be willing to say, yes, you know what? I need this help. I'm willing to take this probation. It's more intense than a regular probation, but I want that help. And so they have their own particular requirements that they have to go through. Harris County has programs in regards to people possibly involved in human trafficking, and this is for the victims of human trafficking. They have their own programs for that, people with drug issues. And so for the most part, most of any issue you can think of where we likely want to see people with rehab, substance abuse issues, veteran issues, we have options available to them. Each court has their own different requirements, and they work in conjunction with the district attorney's office and the courts themselves. But again, that's something for probation typically. Now, post prison, post conviction or release, if I'm honest, I'm just not as familiar with that because as a DA, that's not something that I necessarily work with, and so I just don't have any information about that. I see two questions. Yes, sir.
Crazy question. You live in an adversarial system.
Yeah.
Is there such a thing as overzealous defense attorney?
So I was telling someone earlier, I am engaged to a defense attorney. She's in the public defender's office.
Well, I'm asking the question, is there such a thing as an overzealous defense attorney?
Is there, I mean by overzealous, I don't know what you mean by that in terms of the defense attorney's job is
Do
to
they protect
zealously,
their client too much?
do they protect their client too much? Not if they're doing it within the law. If they're, yes,
Next question, can a prosecutor be overzealous?
of course, yeah, prosecutor be overzealous, absolutely.
Not a defense attorney?
No, I was saying, well, the defense attorney can be, but I'm saying not if they're doing it within the confines of the law, because the defense attorney's job is to zealously advocate for their client. And so if they're making arguments that have merit and they're based in law, that's not being overzealous. So even if, because this is what happens, the question that attorneys get asked a lot is, well, how can you do this? How can you represent this when, you know, there's a confession and they admitted to doing it? Well, if that confession was obtained in violation of the Fourth Amendment, then it doesn't matter what that person said on the statement, because our law says that if you're going to use a confession or if you're going to get a confession, you have to do it a certain way. And so that the defense attorney's job is to make sure that law enforcement and the courts, that they protect, that they uphold those rights. And so if an attorney, as long as they're making their decisions based in law, then that is fine. But yes, if they're doing something that's extra to that or extraneous to that or doing things underhanded, that is improper.
Well, we all know DAs are under way more scrutiny by times up. So I applaud you. That's all.
Sure, thank you. Yes, sir.
Say, for example, you have a criminal case
Uh-huh.
within the county.
I'm sorry.
You have a criminal case. Something you definitely work on in the county. And there is a case of diplomatic immunity.
Then in case of what?
Diplomatic immunity. Is it passed over somewhere else, or you still carry on within the county?
Immunity?
Diplomatic immunity.
Okay, your question is about diplomatic immunity, like what do I?
There is a criminal within the county, cases within the county. But he claims diplomatic immunity. He is working for an embassy of the
Yeah.
foreign government. Is it still allowed to carry on within the country, or it goes to?
So the question is about diplomatic immunity, and honestly, I just don't have particular experience with that. So I would have to speculate in terms of what would happen. Long story short, I just don't know. My guess is that would go beyond me to someone else in my office. We have a general litigation division. That sounds like that might be something that they would have. I've never been in general lit, but I don't know. Yes, ma'am.
You spend 5 days a week in the courtroom, or 2 days in the office and 3 in the court?
Sure. So the question is, do we spend 5 days in court, or is it divided between court and the office? And so it's going to vary from court to court. Generally speaking, though, each court holds docket Monday through Friday. Generally speaking, each court will start around 8:30, 9 o'clock. So generally speaking, each court will have docket Monday through Friday, 9 o'clock to maybe 1 o'clock. Some courts, their docket may last longer because they may put more cases on the docket, so they may get out at 2 or 3 o'clock. Some courts may have smaller dockets, and they may get out at 12 o'clock or 11. But yes, we're in court every day, 9 to 1. And so that doesn't necessarily mean trial, right? And so I was in court today, we had maybe 100 cases on docket. And so what that means is that all those cases are at different points in the criminal process. Some cases are brand new, the person just got arrested, and so they're on docket, so that way the judge can get no conditions of bond, right? No contact with the victim, don't go here, don't do drugs. That's all they're there for, get their conditions. Other cases are older and they're further along, the judge is saying, hey, what are we doing in this case? This case is a year old, 2 years old, whatever it is. Are we going to trial? What are we doing, right? And so every case that's on docket is at a different point in the process. And then occasionally you do have some cases that are on docket because yes, that day they are set for jury trial. And then if it's set for jury trial, then we call over 65 people. We try to see if we can find 13, at least 12, hopefully 13 jurors that can listen to the evidence and make a decision based on the law. Yeah, but we do love our office days if we ever get them. So what I do as a chief, I supervise 2 of the prosecutors. We have 3 prosecutors assigned to a court. And so part of my job is to try to find days for them to be able to stay in the office like, hey, you don't have to come to court today. You can stay in the office and work on cases. And so it's a balance.
You know ahead of time, you read the docket ahead of time to kind of know what's going to be in there.
Yeah, or so the question is, do you read the docket ahead of time to know? Yeah, or at least you better, right? Because everything we do is based on timelines, right? And so if I want the jury to hear a 911 call, I have a deadline on when I need to give the defense attorney notice that that's my intention. If I want the jury to hear about something bad that the defendant did that's unrelated to this crime, but I want the jury to be able to hear about it, the law says I have to give the defense attorney notice. And so that means I have to file things 10 days, 20 days, 30 days in advance. And so if I'm waiting until that name shows up on my docket, that's gonna be too late. Same thing also like in terms of sending subpoenas out, right? If I have a case that's set for trial, I need to send subpoenas out to witnesses saying, hey, you need to come to court on this day, right? And so if I'm waiting until the day of, then that's not gonna be a good result. Yeah.
Another question from our Zoom audience. Why did the family of a person murdered give an opportunity to speak before the judge makes a decision? How long will the guilty person will serve? Does the family contradict the judge's decision?
Okay, so I heard the first part. I'll answer the first part, and then I'll need you to repeat the second part after that. So why does the victim get a chance to address the court?
Why does the family of the person murdered get an opportunity to address the court before a judge is sentenced?
And so that's supposed to take place after the judge after the judge has already announced in terms of 10 years, 20 years, whatever it's going to be, because it's not supposed to impact the judge's decision. But the victim do have a legal right to do what's called a victim impact statement. And so it's just something that our law affords the victims the right. It's not a lot of guidelines around it. Typically, what most judges will do will allow one person from the family to make it. There's no timeline, there's no parameters, there's no limits. We always just tell the victims, keep in mind that you're in court, it's professional kind of thing. And it's that chance to address the defendant without being cross-examined, without being asked questions by the defense attorney. And so I think the reason that the law allows for it is because it's an attempt to try to give closure for victims. Because a lot of times, even after a trial, there are going to be a lot of unknown questions. One thing a lot of times that we might not know in a case is motive. And I might never know motive. I don't have to prove motive, but it's something that families a lot of times want to know. Why did they do this to my son? Why did they do this to my daughter? And I think our law is simply trying to give a chance for victims to get that chance out, because every day I talk to families of victims, mothers and such, and that's a lot of frustration, right? Because no one ever asked to be in this situation. No one ever signs up to be in this position. And it's frustrating when you tell them, this case is 2 years old, 3 years old, and that person is on bond or this and that. And what I always hear all the time is that I have to go visit my son at the grave while this person gets to live their life. And it's frustrating, and I don't have a better answer for them, in terms of that. But what I do tell them though is that they do have rights, like the right I mentioned about doing the victim impact statement. It should come after where the jury has said like what number and such, and so it should not be taken into consideration by the judge in terms of assessing punishment. So that number that part should not be taken into consideration because it's not evidence for that purpose. And what's the second half of the question?
That answers the second half as well.
Okay. Good questions. Yes, ma'am. How can I help City of Katy and the youth? So one thing that I think people have to remember, kind of like I was mentioned earlier, is that everyone charged with the offense, there's a plethora of different things going into it in terms of that person's background, history, how they were raised, and this and that. And so one of the things that I think attorneys need to keep in mind is, okay, what are the full options of things I have available to me, right? And so again, like I was saying earlier, prison isn't always the right solution. At the same time, probation isn't always the right solution. And so what I think we can do, generally speaking, programs that are garnered or that are catered towards help and rehabilitation. So one thing that I've heard mentioned, I even think is a good idea, is even like mentorship like programs. So like particularly like I'm thinking like in like a misdemeanor type setting where you can pair people up that are charged with offenses with attorneys that practice in the court, right? Not because necessarily that you want that person to grow up to become an attorney, but sometimes you just need an example of a professional, right? An example of someone who maybe has had to overcome things in life and got to a point. Sometimes you just need an example of someone who looks like you and see that they've gone and become amazing. One of my favorite things as a former teacher is I have a former student who recently just passed the bar exam. She's now a practicing immigration attorney. And I just think if many people heard her story in her community, how many eyes, how helpful that could be. And so I think one of the things that we could do as courts is to try to emphasize these stories. You know, we hear about the stories about the people, you know, who get convicted and go off to prison, but I think we also could do a better job about publicizing the people who who reform, right? Doing a better job of some of the people who've gone on and do great things after being involved, whether it's a substance abuse issue that they beat, whether it's a drug issue or alcoholism or whatever it is. I think we also need to celebrate the accomplishments of people. And so I think one thing that courts could do is do just that. Because I think once you do that, then people are more willing to then take those chances. Because at the end of the day, you still have to, like I said, you have to want the help. And so if you see people before you went through the program and had success, then that may make you more willing to admit that maybe there's an issue here, and then maybe I can benefit from this particular program. Yes, sir.
So let's say you had
Let's say what?
Let's say you had
Mhm. Right.
Could that disqualify you from big road program?
So wait, so
Yeah.
so you mean the big so I got to go clarify because I work with Big Brother. You mean like the program that I was talking about hypothetically speaking, like the actual program I work with.
Right. So like.
Yeah. So
I'm not definitely hearing you, so I want the kids quite often.
yeah.
Big Brother program.
Yeah. So I don't think so. So if it's like a DWI 30 or something, I think the program at least that I'm envisioning, like the program I'm envisioning is non-existent right now, right? This is something I'm saying that could happen. Yeah, no, I don't think it would. Because I think it would be different. So I think for something like that, it depends on the person, right? Like, you know, like depending on how old the person is, you know, I don't know if they're going to want that kind of mentorship, role. You know, I don't know if there's going to be an issue in terms of like pride or something like that, you know, thinking, you know, like that. But I think it could work. I think you would have to be able to figure out how you want to apply in terms of this and that. But generally speaking, I don't think anything, you know, outside of your violent offenses, I don't think anything should be excluded from a possible help, whether it's through another person or through some type of program. I think that's where we get into the problem a lot of times, where we say, oh, this is the allegation, then we automatically, like, you know, eliminate things. Like, so outside of like, I think violent offenses, you know, DWI or drug cases, human trafficking, I think you have to consider, you have to be able to consider what is the appropriate resolution in this case in terms of to make them community better as a whole. Yeah. That's a question. Question? Yes. Yeah, so the question in case you hear is about being a prosecutor of color. How do you kind of overcome that stereotype that law enforcement isn't necessarily maybe for us or right, that kind of thing. And that's a question I get asked often, right? Being a Black man as a prosecutor attorney, you get different reactions on that. And so I have a couple of answers to that. One is the number of times that the defense attorney has told me that their client felt better simply because I was the person on the other side, right? Not so much because like, oh, he's gonna give me a good deal, or oh, he's gonna let me walk, or anything like that, because they felt like they didn't get a fair shake at it. A fair shake. They just wanted a fair shake at it. Okay, you know what? He understands me. He may understand, you know, that why I didn't immediately stop when, you know, lights and sirens are behind me. He might understand. I might still end up being found guilty or whatever, but I'm at least going through this process thinking I have a fair shake. So that's one way that I'll deal with that. But the other thing too is that I told people before, you know, when we say things like representation matters, we can't always wait until, I just use his name just because he's a police chief, HPD, but you can't always wait until Troy Finner becomes police chief. You know, at some point, Troy Finner was patrol officer Troy Finner, right? And at some point, he then elevated and went on to become that. Same thing with Kamala Harris, right? Before she was Vice President Harris, you know, she was the Assistant District Attorney Harris, right? And so when we say representation matters and things that matter, I think we have to highlight the people that are in these positions in the more lower level positions as they grow up. Because yeah, I get asked that question all the time about being a prosecutor and being a Black man. And you know, a lot of my victims are also African American too, right? So I have a lot of African American victims. I have a lot of victims of all ethnicities and such. And so I think the way I do it is just to make people realize that it's bigger than me. It's bigger than me, and that I acknowledge that there are issues. I acknowledge that racism exists, because it certainly does exist. And if I see a case where I think that's an issue, then you got to call it out. And I think the other responsibility I have, I supervise other prosecutors, typically speaking, just given how long I've been in the office and my tenure that I've achieved. A lot of prosecutors I supervise are not minorities. They might be white. And so I have to make sure that they understand too, that what we see in other places, you know, what we see, news stories that we hear about someone being killed or something like that, that this isn't just some foreign other state, not happening, you know, not relevant here, that these are real concerns, these are real people, and this could be an issue that you can very well face. And so I think part of my job too is making sure that I share my experiences with prosecutors I supervise, while making sure that they also too share with me their experience. Because at the end of the day, what you're combating is ignorance. What you're fighting against is ignorance, and there's ignorance on all sides of it. So what you want to do is make sure that people understand that you just can't cast everything. You can't look at a fact pattern every time and say, oh, that is racist. You can't look at it every time and say it's not racism, right? You have to look at it again, case by case. And so as a Black man, I can't be afraid of what someone may say as being a Black man that's prosecuting a Black person, because he's doing that. Yes, ma'am.
How many convictions do you get with human trafficking?
How many convictions do you get for human trafficking?
I mean, have you been successful in stopping it?
Sure. So the question is about convictions with human trafficking. So I've never been involved in a human trafficking division. I know that they do go to trial often. The issue that you want to have in human trafficking a lot of times is going to be, in fact, the cooperation of your victim, right? Because a lot of times they will disappear. A lot of times that will be intentional. And a lot of times, you know, there's obviously other reliance on the pimp, you know, on the person that's their means of everything. And so I can't give you like a specific number on conviction rates or things of that nature. I can tell you that they do go to trial a lot. They're set for trial often, but I have no idea about like conviction rates or things of that nature. I do know a lot of times that's not always. Well, I don't want to say that. I know a lot of times in those cases, the focus is on making sure that the victim is safe, right? And so sometimes doing that, if the victim doesn't want to cooperate, then that might mean, you know, that the case is resolved with something short of a conviction. But the focus is about trying to make sure that the complainant or the victim is safe. And so in that particular case, you have to sometimes, you have to make decisions that are tough. Because at the end of the day, right, a lot of times people get confused about that. And it's like, oh, but you know he did or this and that, you know, why can't he just, you know, why do we even have to have a trial? It's because you're entitled to a trial. And if you go to trial, you're entitled to have legally admissible evidence produced against you. And so if I have a victim, for whatever reason, that is not going to testify, whether because we think it puts her in danger or because she's afraid and doesn't want to testify, or he, because it goes both ways, If I don't have a victim that's going to testify, then I have to look at my case in a different light and say, can I still prove this case without that victim? That's the issue on domestic violence cases, right? Domestic violence cases, I'm not gonna say it doesn't matter in terms of what the injuries you observe, but just because you have someone and they have injuries, I still have to be able to prove it. And so if that person with those injuries refuses or doesn't want to come to court and testify, it's not enough for me just to put up, in front of the judge and say, hey, here's a picture of her. He must be guilty. She must be guilty. I have to be able to produce evidence in a legally admissible way. So even though the victim told the officer that this person did this, well, we call that hearsay. And that's inadmissible, right? And so I have to be able to produce evidence in a legally admissible way for the judge or for the jury to consider. And so on a human trafficking case, you have to make those decisions sometimes. Putting that victim on this thing, is that going to put that victim in more danger or less danger? What kind of situation, what kind of stability do we have for that victim if she does or if he does testify? It's important to remember that too, because it is not just a sheet of whether it's domestic violence or human trafficking. It knows no sex or anything like that. Yeah. 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 Yeah, and so the question is about COVID and releasing people from the jail. And so that did happen. There was there's overcrowding in the jail. And so typically, at least my involvement, from what I understand about it, every court went through a list of people that were in custody in this court and tried to identify non-violent offenders. So typically, like people with drug cases or people with maybe theft cases, looked at their previous history and they tried to identify people. At the end of the day, it's not me as the prosecutor. I don't have the ability to let anybody out of jail. That is completely a judge call. But the courts try to work together, the prosecutors. The courts ask the people, hey, or ask the prosecutors, hey, when you go through the defendants and try to figure out who you think, could be, like who y'all would not be opposed to, what's called a personal bond, people that you would be opposed to. And there are times even where someone, they might be in custody for a theft case, but they might have violent history. And so that was the task that was before the assistant district attorneys, saying like, okay, this person has this conviction and, 2 years ago, 3 years ago, so we would be opposed here, not opposed here. But at the end of the day, though, the judges of the respective court will have the ability to make that decision. And so the calculus that went into it, the judges to make that decision, I can't say because I'm not a judge, but I do remember having to go through those lists because at the end of the day, right, we talk about Harris County Jail, and this is for people who have not been convicted yet, right? So if you're serving a sentence, that wouldn't apply to you. But if you talk about in the jail, most people in jail have not been adjudicated yet. Most people have not been found guilty yet. And so they're still presumed innocent, right? And so the DAs, along with the courts, we did go through those trying to figure that out because at the same time, even though they're accused of a crime, obviously COVID was happening in the jail as well. And so is it still happening now? I can't think of, we haven't done that recently. I know we haven't had to go through like things of that nature recently to go through and see like, try to see if people should be released. Because generally speaking, the courts are doing that every day. That's kind of what COVID, like when it just happened, nobody knew how to respond. But generally speaking now, courts are kind of addressing that on their own day by day. So there's no like quote unquote mass releases or anything like anything of that nature. Not that I've heard of or been involved with. Yeah.
Very last question.
Yeah.
Very last question. For someone that has to represent themselves.
Yeah.
What would you want that for?
To not do it. Yeah. So the thing is, right? So again, for my criminal cases, so that's what I do. If you can't afford it, you have a right to attorney. And I do want to address that, not because I'm engaged with an attorney, but because I work with attorneys every day. I work with public defenders. I work with the appointed attorneys. We have amazing public defenders in Harris County. And so if someone cannot afford an attorney, they will be appointed one. And there's a stigma that, prosecutors and the defense attorney, they just hang out together, the appointed attorneys, they're like best friends and things of that nature. That's not the case. That's not the case. And so my advice would be really to not do it. We say that and we jest about it, really serious, not do it. and then that if someone is adamant about doing it, it is their right. And most judges, in abundance of caution, will still appoint what's called a standby attorney. And that attorney is sitting at the table with them, you know, and if the person decides not to, because again, it's not just a matter about like, oh, I have all these pictures, I have a recorded statement, I'm going to show to the jury. You have to know how to do it. There's certain questions that you have to ask before the judge will even let the jury see the evidence, you know? And so, if you're going to represent yourself, again, I cannot emphasize enough, do not do it, because you can have the best case in the world, but if you don't know how to ask the right questions for the jury to be able to consider the evidence, it's not going to go well for you. And so, remember, that's a right for criminal cases. Now, in regards to the civil aspect, you know, if you're being sued or something, I don't have any experience on the civil side and things of that nature, but even then, I know there are programs, volunteer lawyer programs, pro bono, training to pro bono work. But in the criminal side, you have an absolute right to have an attorney appointed to you. And now these days, if I'm honest, if you get appointed attorney, and let's say y'all have a working relationship, you know, you don't think that you're doing whatever, if you bring that up to the judge, some judges will allow a different attorney to be appointed. You don't have a right to. You have a right to have an attorney. You don't have the right to choose your attorney. But some judges, you know, if you do show that, you know what, I tried, you know, he doesn't return my calls, or you know, he's not working on my case, some judges will consider that and then appoint a different attorney. But can't emphasize that enough. Don't go to trial on your own. Don't go to trial on your own. I'm an attorney that practiced for 8 years. I would not go to trial. I would not represent myself on a criminal case. Outside of the speeding ticket. Speeding ticket, okay. But outside of that, I wouldn't do it.